Hi, everyone. I wanted to thank you on behalf of our panelists for attending today's webinar training on temporary protected status for Burma, otherwise known as Myanmar. My name is Gisela Perez Kusakawa from Asian Americans Advancing Justice AAJC. I'm joined by my colleague today, Joy de Guzman, as well as our esteemed panelists who I will introduce shortly. Next slide. We would like to thank all of the organizations who have made this webinar training possible, including our co-host, Catholic Legal Immigration Network, Inc., also known as CLINIC, as well as the Lutheran Immigration and Refugee Service and Catholic Charities Community Services Archdiocese of New York. A couple of logistics for today. We ask folks to please plug in their questions in the Q&A section throughout the presentation. Please refrain from waiting all the way till the end. We'd love to hear your questions throughout, and we'll make sure that we can ask those questions, as many as possible, to our speakers. We will have time at the very end for our speakers to provide responses, and we will also circulate the slides following this training to all of the registrants. Next slide. As I mentioned, today's webinar is hosted by Asian Americans Advancing Justice, AAJC, and CLINIC. Next slide. Here at Advancing Justice AAJC, we know that Asian Americans have been a part of the American story since its earliest days, and are now the US's fastest growing racial group with the potential and power to shape our nation and the policies that affect us. Next slide. Our mission here at Asian Americans Advancing Justice is to advance the civil and human rights for Asian Americans and to promote and build a fair and equitable society for all. Next slide. We have been joined by Catholic Legal Immigration Network, which is the largest charitable legal immigration network in the nation. CLINIC provides substantial legal and program management training and resources, as well as advocacy support at state, local, and national levels. They train nearly 10,000 people each year on immigration-related topics. Next slide. The Catholic Legal Immigration Network, Inc. promotes the dignity and protects the rights of immigrants in partnership with their network of immigration legal providers, which includes more than 380 nonprofit organizations in 49 states. We thank them for working with us in hosting this organization, as well as our other speakers for joining. Next slide. Today, we are joined by 4 esteemed panelists. They will be covering 4 main areas. First is a broad background on TPS. I know many are wondering what is TPS generally and how the TPS for Burma came about. Second, what makes you eligible for TPS, and we'll be able to walk you through the application process and discuss benefits. Third, we'll discuss the practical issues and give concrete examples that will allow you to better understand how this applies in real-world situations. Lastly, we'll have consideration for program management. Next slide. And so for our first topic, we are joined by Jill Marie Buzzi from the Lutheran Immigration and Refugee Service. Next slide. Jill serves as the Director for Public Policy of the Lutheran Immigration Refugee Services, where she leads in developing and promoting immigration and refugee policy recommendations. We thank her for joining us and lending her expertise. I turn it over to you, Jill.
Good afternoon, and thank you all. I'm very grateful to be here with you all. I'm quickly going to review what temporary protected status, or TPS, is under the law, and then I will cover why DHS Secretary Mayorkas designated TPS for Burma. So first, Congress created TPS in the Immigration Act of 1990 based upon the principle of non-refoulement, and with the intent to protect foreign nationals who are already in the United States from being returned to their home country if it became unsafe during the time that they were here, and it would put them at risk of violence, risk of disease or death to go home. Stated another way by the Congressional Research Service, TPS is the statutory embodiment of safe haven for foreign nationals within the United States who may not qualify for asylum, but are nonetheless fleeing or reluctant to return to potentially dangerous situations. Under the law, the Secretary of the Department of Homeland Security, or DHS, has the authority to grant TPS. The Secretary must consult with other government agencies prior to deciding to designate a country. The other agencies are not specified in the statute, but the consultations usually involve the Department of State and the National Security Council. The statute enumerates a country may be designated TPS for one or more of the following reasons: an ongoing armed conflict, such as civil war, an environmental disaster, such as an earthquake, hurricane, or epidemic that results in a substantial but temporary disruption of living conditions, and for extraordinary and temporary conditions in the foreign state that prevent its nationals from returning to the state in safety. Okay, so we're going to move on to the next slide. Now that we know more about who can grant TPS and the reasons why, it's important to understand that TPS is not from the perspective of the person who, what TPS is, and not from the perspective of the person who may be eligible. Elissa and Jen are going to cover that. Essentially, TPS provides a temporary immigration status for nationals of the country designated, or for individuals without nationality who last habitually resided in that country. The length of the TPS grant could be 6, 12, or 18 months. And it really is a humanitarian form of protection that provides protection from deportation and work authorization for eligible persons. But they must register or apply with the U.S. Citizenship and Immigration Services, or USCIS. So TPS is a temporary status, and it's limited in nature in several ways. First, the designation by the DHS Secretary is subject to review and potential extension also. And the statute does not provide a pathway for TPS holders to transition directly to lawful permanent residency or green card. Okay, next for us is to understand why DHS Secretary Mayorkas made the decision to designate TPS for Burma. So we're on to, yes, exactly, this slide. This is just a sampling of the headlines since early February of this year. In my role at LIRS, we were tracking this very closely, as LIRS has been involved in assisting refugees from Burma relocate to the United States. Over the last 20 years, we've resettled almost 7,000 Chin people, and our affiliates are still actively providing services to resettled refugees from Burma. So for the last 2 decades, we've worked really closely with Chin leaders in the United States and the United States Catholic Conference of Catholic Bishops to conduct visits to Burma to stay abreast of the situation there. While we have come to know the courage and perseverance of the Chin people and many in Burma, we understand the persecution many have suffered because of their religious or political beliefs. We were very distressed to see the military seize of power on February 1st and the deposition of democratically elected leaders and the one-year state of emergency that immediately began. We began to collaborate and jump into action when we saw this with the organizations that are represented here. And we sought to engage the administration on options like TPS that may provide protection. So on to the next slide. We were very pleased to see that the administration was also tracking the situation in Burma. And on March 12th, the Department of Homeland Secretary Mayorkas announced the designation of TPS for Burma. In a press statement, DHS announced that Secretary Mayorkas had decided to designate Burma for TPS after consultation with these interagency partners and careful consideration of the extraordinary and temporary conditions in Burma that were caused by the coup, which also led to continuing violence, pervasive arbitrary detentions, and the use of lethal violence against peaceful protesters and intimidation of people in Burma. The coup worsened humanitarian conditions in several areas by limiting access to life-saving assistance, disrupting flights carrying humanitarian and medical aid, and spurring on an economic crisis. The announcement also indicated that there would be a forthcoming Federal Register notice, which is the mechanism which USCIS, the Immigration Service, provides more detail about the rationale for the designation and, of course, the instructions for how people would apply. Okay, on my final slide. 74 days after the DHS secretary made the public announcement about designating Burma for TPS, the Citizenship Service finally published the Federal Register, or FRN, which provides much more detailed information about the reason for the decision, which is quite lengthy. So I'll just summarize the key reasons, which are: one, the political crisis. Obviously, the Burmese military seized power in a coup against the democratically elected government. They also cited human rights abuses, and the Federal Register notice goes into a lot more detail, but generally they cited violence committed by the police and military forces, arbitrary arrests and detentions, danger of vulnerable groups, including Rohingya Muslims and other ethnic minorities. And the final prong of the rationale was the humanitarian crisis in Burma that was triggered by the coup, including the disruption of communications and limited access to medical care. The FRN, as I mentioned, the Federal Register notice also provides instruction on how individuals can register for TPS and avail themselves of this protection and apply for work permits. So my former colleagues from Clinic, Elissa and Jen, are going to lead you into covering that aspect of TPS.
Thank you so much, Jill. You very much communicated the frustration with the delay and our relief upon the publication in the Federal Register. As Jill mentioned, our next speakers are Elisa Mira and Jennifer Riddle from Clinic. Next slide. Elisa Mira has been a staff attorney with Clinic's Oakland, California office since 2013. She provides training and legal support to member agencies and other organizations nationwide. She has provided legal assistance to individuals applying for DACA and naturalization and represented U visa and asylum applicants. Next slide. Jen Riddle has been a staff attorney with Clinic since 2014. She also provides training and legal support as well nationwide. She has previously worked as an advocacy attorney for Clinic's state and local immigration project and has previously advocated for the protection of refugees and asylum seekers at the United Nations High Commissioner for Refugees in Washington. I turn it over to you, Jennifer and Elisa.
Great, thank you so much, Gisela, for inviting us, and thanks to all of the panelists today. So Jill touched on this, but we wanted to start with kind of clarifying what TPS gets you, what the benefits are. So you cannot be deported while you're in TPS status, so you get temporary protection from removal. And TPS is a type of temporary lawful status. So this is helpful for someone who, let's say later, wants to apply to change into a non-immigrant status, or possibly even apply for lawful permanent residence. If you have valid TPS, you can get an employment authorization document or an EAD, that's a work permit. And we'll be talking about how to apply a bit later, but you can apply at the same time that you file for TPS. You can also apply for work authorization at that time. Once you are work authorized, as you know, you can be assigned a social security number and receive a social security card. Somebody who has TPS can travel abroad with advance permission. So that permission comes in the form of what's called an advance parole document. And the TPS holder needs to apply for advance parole and be issued advance parole before they depart the country. TPS does not confer derivative benefits. So if you get TPS, that's not going to provide your spouse or your child with TPS also. So a spouse or child would need to be independently eligible for TPS and file their own application. All right, so let's move on, and we're going to talk about who qualifies for TPS. So what are the eligibility requirements? And these come from the statute at INA section 244C. And then we also list here the corresponding regulations at 8 CFR. So that's kind of where the general requirements for TPS are. In terms of the specifics for a particular country that's been designated, those details are spelled out in the Federal Register notice that Jill mentioned and linked to in her slide. And they're also on the USCIS website under the TPS Burma page. So first you have to be a national of Burma or someone without nationality who last habitually resided in Burma. So a national is someone who owes allegiance to a particular country. Typically here we are talking about citizens of Burma. And we're going to speak more later about those who may not have nationality and may be considered stateless. But our sense is the majority of eligible folks here will be needing to show that they are a Burmese national. The next two requirements relate to residence and presence in the US. So you have to prove continuous residence in the US since March 11th of this year. And you have to prove continuous physical presence in the US since May 25th. That's the date the Federal Register notice came out. So note those two different dates. And these terms are defined in the regulations. They're similar concepts, but they're not the same. So continuous residence requires residing in the US since March 11th. So the US is the place where you reside, it's your home, it's where you live. Continuous physical presence means you are actually here physically inside the US. So you must have been physically here starting May 25th. The law allows an exception to the residence and presence requirements for certain departures from the US. So your client isn't necessarily doomed, let's say, if they've been residing in the US for the last year, but maybe they left on a brief trip. To qualify for this exception, the absence must be brief, casual, and innocent. Well, what does that mean? So it has to have been short in duration, and it has to have been reasonably calculated to accomplish the purpose for the absence. So if somebody had to leave, let's say to go to a funeral of a relative, maybe several days or a week or two could be short and reasonable, but being gone for, let's say, 6 months, probably not reasonable given that particular purpose. The absence cannot have been the result of a removal order or a grant of voluntary departure. So if a judge ordered you removed and you were deported by ICE, that's not going to qualify. And then the purpose for the absence cannot have been contrary to law. So you can't have left the US to go engage in illegal activity overseas, for example. If your client has a short absence, they may not have disrupted their residence and their physical presence, but it will have to fall into this exception and you'll have to do that analysis. All right, moving on. So even if you meet those eligibility requirements we just talked about, you're not eligible for TPS if any of these bars apply. So the first one deals with crimes. If you've been convicted of any felony, so one felony, or 2 or more misdemeanors committed in the US. So just to remind you, the definition of a conviction for immigration purposes is not the same as the definition of a conviction under state criminal law. So you're always going to need to look at the client's criminal history, the statute of conviction, look at the disposition documents, and determine whether or not they have a conviction for immigration purposes. In the TPS context, a misdemeanor is defined as a crime punishable by an imprisonment term of more than 5 days and up to a year. And that's regardless of the term that was actually imposed, or sorry, the term that the client actually served in reality. A felony is a crime punishable by imprisonment for more than a year, again, regardless of the term they actually served. There's an exception where even if the offense is punishable by more than a year, if the state defines it as a misdemeanor and the sentence actually imposed was 1 year or less. In that case, it would be treated instead as a misdemeanor. So those are the crime bars. A TPS applicant also has to show that they are admissible. And if you are not, if you are inadmissible under a ground of inadmissibility that applies to TPS applicants, and you're not eligible to waive that ground, then you're not eligible for TPS. So we've listed here, there are 3 grounds that don't apply to TPS applicants. That's 212A4, the public charge ground, 212A5 is the labor certification grounds, and 7AI relates to documentation requirements for immigrants. So those don't apply if you're applying for TPS. But the remaining inadmissibility grounds under 212A, they do apply. Now they can all be waived with the exception of certain criminal and security related grounds. So certain of the 212A2 crime grounds and drug offenses cannot be waived. And then also the 212A3 grounds that relate to national security, terrorism, genocide, Nazi persecution. So those cannot be waived. But all of the remaining applicable grounds, you can seek a waiver. And so that waiver can be granted for humanitarian purposes, to assure family unity, or when it's in the public interest. So it's a very generous waiver standard consistent with the humanitarian nature of TPS. And then finally, the last set of bars are, these are called the mandatory bars to asylum. They appear in the INA section 208. And these include if you participated in the persecution of others, a conviction for a particularly serious crime, reason to believe someone has committed a serious non-political crime outside the US, terrorist activity. And then I would say the one that probably comes up the most frequently with clients, and that is the firm resettlement bar. So that is being firmly resettled in another country prior to arriving to the US. And Elissa is going to talk more about this bar in particular a little bit later, because there are many people who might otherwise be eligible for TPS, but perhaps after fleeing Burma, they lived in a third country for a period of time. So we want to know how to look at those cases. All right, so now we're going to move on and talk about how to apply. What's the process? Assuming you've screened your client, you've determined that they're eligible, what do you need to do? And I'll pass it over to my colleague, Elissa.
Thank you, Jen. So the first thing that we wanted to remind people is that there is an application period in which people should submit their initial registration for TPS. It opened on May 25th, and it's open until November 22nd, 2021. So anyone who's interested in applying for TPS should apply within that period. There is the possibility of filing a late initial application that however still requires that you meet the eligibility requirements for TPS during the time it was announced. So it doesn't really help people who are new arrivals who may not have initially qualified for TPS. It's more for people who, when TPS was initially announced and during the initial registration period, for example, they may have already had another type of status, or they may be pursuing another type of status, and that's what prevented them from initially applying for TPS. So we encourage people to apply within the current registration period. In order to apply, there is a form that's required, Form I-821. And there is a $50 filing fee for all initial applications for TPS. And then in addition to that, there's an $85 biometrics fee. It's the fee that's required for doing the fingerprinting and the background checks. This is required for anybody who's 14 years or older. People who are under 14 are not required to pay that biometrics fee. And again, there is a fee waiver available for people who are unable to afford the filing fee and the biometrics fee. So that can be waived. In addition, you would also want to submit evidence that shows you meet all of the eligibility requirements for TPS. So evidence of your identity and of your Burmese nationality. And as we mentioned, if you are not a Burmese national, but you are someone who was stateless and last habitually resided in Burma, then you would want to include evidence of that as well. So evidence of nationality, primary evidence of nationality, typically people would be submitting passports, copies of their birth certificate, plus a photo ID, some kind of national identity document that would include a photo and or fingerprints. But if those types of primary evidence are not available, you can also apply using secondary evidence. So let's take a look. Well, before I move on there, I just want to say about secondary evidence. If you're not able to obtain a passport, you don't have a birth certificate, what you would want to do is explain the steps you've taken to try and obtain those primary documents. What has the person done to try and obtain them, and what is their explanation for that being unavailable? And if those documents are unavailable, you also want to include an affidavit attesting to the fact that they are a Burmese national or that they last habitually resided in Burma. Some examples of secondary evidence that people might want to look into would be things like school or medical records, other types of immigration documents, any other documentation that might include some reference to their nationality and their identity. And those are also documents that could be used to show last habitual residence in Burma if that person is actually stateless, but last lived in that country. And then other documents that can be included would be affidavits from friends and family members who have personal knowledge of the facts that make the applicant a Burmese national, or who can attest to the fact that the applicant has no nationality but last habitually resided in Burma. And that person who's going to submit the affidavit should include information about how he or she knows the applicant, what's the relationship, how is it that they know the details of the applicant's nationality, or that the applicant last resided in Burma. And so those can be options if the person's unable to get primary evidence of their nationality. So the other things that you would have to prove, as Jen mentioned, you'd have to include evidence to show your proof of entry into the United States, and that goes to meeting the continuous residence requirement as well as the physical presence requirement. So again, you want to include evidence to show that the applicant has been residing here in the United States since March 11th, 2021, and also that they've been physically present here since May 25th, 2021. And the types of evidence you would use to prove both of those things are similar. You might be including an I-94 arrival departure record, which indicates when the person first arrived in the United States. You might be including employment records, pay stubs, W-2s, tax documents. If the person has been paying rent for their accommodations, if they are paying utility bills, bank transactions that are dated and in their name. Those are all types of evidence that can be included to show that the individual has been living here in the United States. And so you want to look at those kinds of things. Affidavits as well can be included. Birth certificates of children born in the United States. So there are a lot of examples. There's not an exclusive list of documentation that can be accepted. And you want to look at what you might have available. If you're looking for more information about what kinds of documents are accepted, you can take a look at the instructions to the I-821, which go into detail about providing examples of documents that can be used. So a few other things that you might include in the application. We go to the next slide. So if the individual has ever been arrested, charged, or convicted of a crime, they're going to be asked to disclose that on the I-821. And that goes to some of the eligibility issues that Jen described earlier. And so you'll want to have copies of any final court dispositions that would be included with the application. The person completed probation, for example, you would want to provide proof that they've completed that probation. The instructions also ask about records related to foreign convictions. So that's something that you want to ask about. If those records are unavailable, then you'd want to provide an explanation as to why they can't be obtained and included with the application. Jen mentioned inadmissibility issues. And so if the person is inadmissible for certain grounds, that apply to TPS, they can include an inadmissibility waiver. It's a form I-601 if that's applicable. There's a separate fee for that as well, but I believe that can be waived. And then it's optional, but if the applicant is interested in getting a work permit based on their TPS, they would include form I-765. Again, there's a filing fee for that. It's $410 for anybody between the ages of 14 and 65, but that can also be waived. And then for people who are younger than 14 or older than 66, there's no filing fee required. You don't have to apply for that work permit at the same time that you're applying for TPS. So if the person, for example, doesn't need a work permit right now and they don't want to request one at the moment, they can request one later on if they, based on their pending a TPS application or based on having a TPS approval. And we've gotten some questions about this in the past. You would submit that application in the category A12 for an initial TPS EAD. And then the instructions to the I-765 indicate that you should also include 2 passport photos as part of the supporting documentation. I would just mention that you want to confirm the correct filing address where to submit those applications. They're being currently sent to the Chicago lockbox, and you have a link there to the USCIS website where you can find information specifically about Burma TPS and where you should submit your application. They also have a number of helpful checklists available. You can find information there to confirm eligibility dates as well. All right, so I wanted to come back to 2 eligibility issues that you might want to look out for that are specifically for the population of people who are from Burma. So let's take a look at that. Jen mentioned this issue earlier, stateless applicants. So as she mentioned, in order to be eligible for TPS, you have to be a national of the TPS country that was designated. Or if you are someone who's considered stateless, you have to show that you've last habitually resided in that TPS country. And so we've seen that there are a number of questions coming up for people from Burma, particularly people who are from ethnic or religious minorities. I'll just say that the current Burmese citizenship law is very, very complex. There is a significant population of people who were born in Burma, whose parents were born in Burma, who were raised in Burma, and yet they're not considered citizens by the state. And many of you are familiar with the country's practice of denying or even revoking citizenship for many people who are members of religious or ethnic minorities, including the Rohingya. But it also affects other minority populations like Burmese people of Indian descent or Chinese descent, other ethnic and religious minorities, such as the Karen or the Chin, people who should be considered citizens under Burmese law, but are often unable to obtain documentation to show that they are citizens. So there are a number of issues there that make it very difficult for many people to obtain either citizenship or even just proof that they are citizens because of a number of reasons, including administrative delays and arbitrary application of the laws, discrimination. So what I just wanted to note is that individuals can still be eligible for TPS if they are stateless, if they can show that they last habitually resided in Burma. So this is not going to necessarily help people who have fled Burma and were residing in a third country before coming to the United States. So people who fled to Thailand or Malaysia or Bangladesh before coming to the United States, they're probably not going to be able to show eligibility for TPS if they're stateless. But it is a possibility if they last resided in Burma, they would have to be able to show that residence, however. And so documents that could be available for some people might include national identity documents. So some people may have access to a temporary registration card or a national verification card. Again, if they've got proof of marriages or births that took place in Burma, some people might be able to receive a UNHCR determination of statelessness. So you want to think about the types of documents that they might have available to show that they did last reside in Burma. And again, affidavits might potentially be used for that purpose as well. So we do want to acknowledge for some people, it might be very difficult if they've been internally displaced, or if they're a member of one of these groups where it's very difficult for them to obtain documents. We just want to acknowledge that that's potentially going to be a problem for some people, but it's not necessarily a bar to qualify for TPS. So there's related to statelessness, or actually related to this issue of last habitual residence, there's another issue we wanted to talk about, which is firm resettlement. So if we go to the next slide, firm resettlement is a concern for people who may be Burmese nationals, but prior to coming to the United States, they lived in a third country. And so that's considered a bar for TPS. You are considered firmly resettled under the regulations if you physically entered into a third country prior to arriving in the United States, and you were offered or received some type of permanent status while you were in that country. And so that's potentially going to be an issue for some folks. Whether someone has been resettled is really a complex determination, and it is very fact specific. So it's difficult to say, for any specific person without knowing their facts, whether or not they might be considered firmly resettled. But you would look at what type of status they received in that third country. Did they have some kind of legal status that could be considered permanent? What are the laws of that country? Who is entitled to that type of status? And then what are the terms of that status? Can it be renewed? Can it be terminated? The length of time someone spent in another country doesn't necessarily determine whether or not they've been firmly resettled. So there are a couple of exceptions to firm resettlement for people who may have had some type of status in a third country. And if we go to the next slide, we can take a look at those two exceptions. One is that their entry into the third country was a necessary consequence of their flight from persecution, and that they stayed only as long as necessary to make travel arrangements to move onward, and that they didn't establish any significant ties to that country, meaning they don't have significant family ties, employment ties, social ties, and that really at their first opportunity to move on, they did move on. Another exception would be for restrictive conditions, meaning that even if somebody was able to live in another country, potentially with some type of status for a period of time, the actual conditions of residence were so restricted that he or she cannot be considered resettled. So to qualify for that exception, you would look at the rights and the privileges that that person actually had in reality in that third country, compare that to the rights of other permanent residents there. So we're looking at, were they able to obtain housing and employment? Did they have the same access to those things? Were they able to obtain property, to travel freely, to obtain education? Those are all factors that you would look at. And for many Burmese migrants who may have been living in other countries, we know that there certainly may have been restrictive conditions for them in other countries where they were residing in. So why don't we just take a look at an example here to kind of help illustrate how that might work. So if we take a look at this slide here, is Leon eligible for TPS? Leon lived in Thailand for 2 years before he arrived in the US. While in Thailand, he had a 2-year visa that allowed him to work. So is he eligible for TPS, and what factors should you consider? So if you want to type into the chat box, we can take a look and see what people think about whether or not this person could be eligible for TPS, or what you would want to consider here. I would say that the first thing we would want to look at was there an offer of permanent residence or citizenship? And it doesn't seem like that's the case. We would need more information, but it appears that he had a temporary status. We'd want to know what types of privileges that might provide. Does that allow him to remain in Thailand indefinitely? Doesn't sound like it does. It doesn't sound, we don't know whether this is renewable or not. So that might be enough to avoid finding a firm resettlement. But if it does appear that he could potentially have been firmly resettled, you would want to look at exceptions that could apply. So did he develop any significant ties while he was in Thailand? And what were the conditions of his residence there? Were there restrictive conditions? So again, we want to know, what did this person experience? Are they a member of an ethnic or religious minority that's also experiencing discrimination in Thailand? What are the restrictions on his ability to obtain housing and employment and have his family with him? So those are all things that you'd want to consider. We can't just assume because he had some lawful authorization to remain in Thailand that means he's firmly resettled. So that's just a kind of a quick look at this issue so that people are aware it's something to consider. Another issue that might come up for potential TPS applicants is that they may already be seeking other types of relief, such as asylum, or maybe they have another type of status here in the United States already. So we wanted to look at what some of the important considerations are for people who are in that situation. And I'm going to pass things back to Jen to look at that.
All right, great. Thank you, Elissa. Excuse me. So on the next slide, we're going to talk about kind of the intersection of TPS with other types of status. So I know many of you probably have Burmese clients who have some other kind of status, or you may yourself be one of those people. Many may have entered the US as refugees, resettled from abroad, or perhaps come here and then been granted asylum. And for those clients, refugees and asylees, they are already on a path to lawful permanent residence. TPS isn't going to offer them any real benefit. TPS is just a temporary form of protection. So it's probably not going to be relevant for that specific population. But you may have clients who have a pending asylum application. They're not an asylee yet. They've filed for asylum. And asylum leads to LPR status, lawful permanent residence. TPS doesn't. And so these people don't want to do something, obviously, to jeopardize their asylum claim. But they want to know, well, should I also file for TPS? Or you may have clients who are in some kind of non-immigrant status, an F1 student, for example, somebody who came in as a B2 tourist. And so non-immigrants like F1s and B2s and J1s, non-immigrants can apply for TPS. So you can simultaneously hold a non-immigrant status and be protected under TPS. Likewise, it's fine to have a pending asylum application and apply for TPS. But there are some considerations, some things you want to think through before you make a decision to proceed with TPS. So let's start with pending asylum applicants. Kind of the main question here is, does the person have an affirmative asylum application that's pending at USCIS at the asylum office? Or do they have a defensive asylum application in immigration court? And the reason that this matters is because for someone who's applied with the asylum office, if the asylum officer does not grant the asylum application, let's say they look at all the evidence, you go to your interview, they decide you haven't shown that you have a well-founded fear of persecution. If at that time the asylum applicant has valid status, and that includes that they've been granted TPS, the asylum officer cannot refer the case to the immigration court. So typically it would get referred to the immigration court, where the person would get kind of a second chance to renew their asylum claim with an immigration judge. But in this instance, if the asylum office is not going to approve the case, their only option is to deny it. And the regulation that governs this is 8 CFR 208.14 C2. And it says an affirmative asylum applicant whose application USCIS decides it cannot approve cannot be referred to EOIR if the applicant is maintaining valid immigrant, non-immigrant, or TPS at the time the application is decided. Instead, the asylum officer shall deny the application. So this isn't going to affect everybody. It's really going to depend on the particular case. You know, there may be a case where if your client was denied at the asylum office and not referred to court, that could, you know, not be detrimental to them. So if your client has a weak asylum claim, it's not likely to be granted by an immigration judge, and they don't have some other form of relief that they would be applying for in immigration court. In that case, you know, it may be in their best interest to have TPS. They're not losing anything by missing that opportunity to be referred to the Executive Office for Immigration Review or court. But if your client does want to have that opportunity to renew their asylum claim before an immigration judge, you don't want them to have valid TPS status at the time that USCIS is deciding not to approve their application. They get approved, you know, it's fine. So anyway, the point is that they may want to hold off on filing for TPS for now and see what happens after their asylum interview if the case is approved. Now, if you decide to hold off on applying for TPS, there is this possibility of late initial registration for TPS. It would be an option as long as the TPS designation for Burma gets extended next fall. And the client would need to file for TPS during the extension period and within 60 days of their asylum application being denied. So that's just something to think about. Another consideration for pending asylum applicants and other people who have lawful status deals with EADs, employment authorization documents. So if your client has a C8 EAD, they have an EAD based on being a pending asylum applicant, look at when that expires. These are 2-year EADs. An EAD coming from TPS is only going to be valid through the duration of the TPS extension, so currently through November of next year. So if your client has an EAD, a 2-year EAD, they could apply for TPS, they could file the 821, but they don't have to apply for a TPS EAD if it's not going to give them anything. You do want to be a little mindful of EADs when you're talking about certain non-immigrants. So as I said, somebody in non-immigrant status can apply for TPS. They can be granted TPS and not impact their non-immigrant status. But to kind of simultaneously have non-immigrant status and maintain TPS, you have to remain eligible for both types of status, so to speak. So you have to think about the impact of deciding to work on a TPS-based EAD if you're trying to maintain F1 status, for example, or you're trying to maintain B2 status. So we know that B2 tourists are not work authorized. If you work while you're here in B2 status, you will violate your B2. Working on a TPS EAD as an F1 student could violate your F1 status if your Form I-20 doesn't allow for work authorization. So you need to help clients think these issues through, you know, if not before they apply for the EAD, certainly before they go ahead and present that EAD to an employer to work. I think I already mentioned the possibility of late initial registration for TPS within 60 days of losing non-immigrant status or having a pending asylum application denied. So to kind of flesh this out a little bit more, let's look at the next slide. And we'll do an example here. So I'll read this, and then if people want to chime in the chat box about what you think, we'd love to hear your thoughts. So Nala entered the US from Burma as a B2 visitor in 2018. Her affirmative asylum application has been pending with CIS since October 2019. Her boyfriend, Sue, also from Burma, is here in F1 status and plans to graduate next year. Should Nala and Sue apply for TPS? What factors should you consider? All right, so let's start with our pending asylum applicant, Nala. So she can certainly apply for TPS. This would give her kind of a fallback status if she were not to be granted asylum. And, you know, if she has her asylum interview soon and she gets a decision before November 22nd, which is the filing deadline for TPS, you know, there's really no issue. But if she applies for TPS and she is approved, she gets TPS, then let's say she goes to her interview and the asylum officer decides, I can't approve your claim. What's going to happen? Is she going to get referred to immigration court where she's going to get this second chance to raise her asylum claim? No, she's not. If she's in valid TPS status at that time, she cannot be referred to court. So again, you kind of want to think strategically, look at the basis of your client's claim, how strong it is. If she decides not to proceed with TPS now, she could, as we discussed, qualify for late initial registration in the future if her asylum application does end up being denied. All right. Sue is an F1 student, graduates next spring. So here, you know, I would ask questions about what his plans are after graduating. Does he want to pursue another course of study, or does he want to work? Is he going to be eligible for a full year of OPT when he finishes his studies? So getting TPS could be a great backup for him to rely on once his F1 status ends. And I don't see an issue with him applying for a TPS EAD, but he should not use it to work without first assessing whether working would violate the terms of his F1 status and thus cause him to lose F1. So for him, I don't see a downside in him filing for TPS. You can be enrolled in university and school as a TPS holder. I believe in most states, TPS actually allows students to qualify for in-state tuition, while F1 status does not. If he doesn't apply for TPS now, again, he could qualify for late initial filing later. And because TPS is considered a non-immigrant status, once he gets TPS, he could potentially apply to change back into F1 or you know, switch into H1B, for example, at some point down the road. All right, so we wanted to talk quickly about some considerations related to adjustment of status, applying to become a lawful permanent resident, and that's on the next slide. So just kind of, again, to be very clear, getting TPS, this alone does not put you on a path to lawful permanent residence or LPR status. TPS is temporary, doesn't lead to you becoming eligible for a green card under current law. You know, hopefully that will change, but however, there are TPS holders, TPS beneficiaries who are eligible to adjust to LPR status through some other path. Family-based immigration, for example. Maybe they have a US citizen or LPR relative who's filed a petition for them. Or maybe they have an employer sponsor who's willing to sponsor them for employment-based immigration. So there have been a few ways that having TPS has been able to help some of these people become eligible to adjust status here in the US through one of these other paths, like family immigration. And this is complicated if you're not really like a full-time immigration practitioner, so don't be overwhelmed by this. But just kind of as background, if you're applying to adjust status under INA 245A, you have to show that you're inspected and admitted to the US. And it used to be that if you lived in a state under the jurisdiction of 3 circuit courts, those were the 6th, 8th, and 9th circuits, your grant of TPS was considered an admission for purposes of adjusting under 245A. So what this meant is that even if you initially entered the US without inspection, you didn't come in with a visa legally, you came in, you know, surreptitiously across the border, came in with a smuggler. Even if you came in illegally, so if you resided in one of these circuits and you had been granted TPS, And let's say you were an immediate relative, so you had a US citizen spouse who petitioned for you, you could become eligible to adjust status here in the US because your grant of TPS was considered an admission. This was not permitted in any circuit outside of those three that I mentioned. Now, there was a circuit split. People were being treated differently depending on where they resided. And so this went up to the Supreme Court. You probably heard a lot about this on the news over the last few days. There was a ruling on Monday where the Supreme Court unfortunately held that no TPS recipient who originally entered without inspection can adjust status based on their TPS grant being considered an admission. That's the holding of the Sanchez case. Once that decision goes into effect, TPS holders across the country will not be considered admitted by virtue of their grant of TPS. So that's one thing we just wanted to clarify, and I know people may have questions about that. Another thing is that it used to be that TPS holders who initially entered without inspection, again, that we're not talking about people that came in on a visa and overstayed, people that came in without inspection, but they were eligible to adjust through a family-based petition. They could get advanced parole, leave, come back in, and then that return with advanced parole would count as an inspection and admission or parole, again, to adjust under 245A. Unfortunately, this was changed last year by USCIS. They changed their policy. So anybody who returned with advanced parole after August 20th of 2020, any TPS holder, would no longer be considered admitted or paroled to therefore adjust under 245A. So that's the matter of CRZC case. And then finally, we just wanted to mention TPS has been considered lawful non-immigrant status for purposes of the 245C bars to adjustment. And those would apply to those of you who do family immigration to preference category relatives. So immediate relatives are exempt from the 245C bars, but preference relatives have to show that they've always maintained lawful non-immigrant status, and being in TPS is considered being in lawful non-immigrant status for purposes of 245C. So if a preference relative initially entered without inspection, they were out of status before they got TPS, they're going to have a 245C bar. All right, and then we have a link here at the bottom. This is the clinic's practice advisory on adjustment options for TPS beneficiaries. We haven't updated this yet following Monday's decision, so we're going to do that shortly, but it can be something to look at if you want to know more about this issue. All right, in just the last few minutes here, on the next slide, we kind of wanted to close with some basic practice tips for practitioners. In terms of screening clients for TPS eligibility, remember those bars that we discussed. So when you're trying to decide if somebody has a felony or they're barred for having 2 or more misdemeanors or they're inadmissible under a crime-based ground that cannot be waived, you're going to need to know their criminal history. And so you may want to file FBI background checks. You may want to get your client's criminal dispositions. In terms of assessing inadmissibility, you would also want to get somebody's immigration history. So you may want to file FOIA requests, Freedom of Information Act requests with a particular government agency. So because of the time that it can take to gather these documents, you may want to get a head start on this as quickly as you can. And I don't think we've mentioned this, but if someone applies for TPS and it's denied on the basis that the person is inadmissible, the law is that a notice to appear will be issued. So for clients who aren't currently in immigration removal proceedings, you don't want them to apply if it's clear that they are inadmissible and not eligible for a waiver, because that's going to put them into removal proceedings. They would, of course, have the right to a de novo determination of their eligibility for TPS before the judge, but just be careful in your screening. We mentioned that TPS beneficiaries can request advanced parole. If that's something your client is interested in, make sure you discuss the risks of travel with them based on their specific circumstances. We don't want clients to travel if they could potentially trigger inadmissibility when they return. If they have an underlying non-immigrant status or a pending asylum application, you're going to need to think through the implications of traveling on advanced parole to that status or that application. Since this is a new designation for Burma, make sure clients understand a lot of what Jill covered, how TPS works generally, that they're going to need to re-register for TPS each time the designation for Burma is extended. Again, assuming that it's extended prior to next November. If you don't re-register on time, your TPS status will be terminated. And there is a possibility of late re-registration, but it's only an option if you can show good cause for re-registering late. So it's best to apply as early as possible to re-register. So make sure clients know about this and that they're going to come and check back in with your office next year. You also don't want them to have any lapse in their employment authorization if possible. So again, TPS is temporary. It doesn't lead to lawful status. Make sure you are screening clients to see if they are eligible for something more permanent. If they do have a family-based path to residence or an employment-based option, or maybe they're eligible for another humanitarian benefit that does lead to permanent residence, like asylum or U visa or T visa, VAWA, those sorts of benefits. This may be for many people the first time they've spoken to an immigration attorney, and it's really kind of a great opportunity to holistically assess their entire immigration situation, not just determine whether or not they're eligible for TPS. And then lastly, you're probably aware there is a lot of advocacy going on to push Congress to create a path to residence and legalization for TPS holders. So the American Dream and Promise Act, this is HR 6, this passed the House in March with bipartisan support. It would protect all current TPS holders and provide them with a pathway to lawful permanent residence. This has not passed in the Senate. We don't know what's going to happen or what the chances are, but just make sure you're keeping up with developments as far as legislative solutions for TPS holders. And then our last slide really just links to some of clinics' TPS resources that may be helpful to you. This is on the next slide. So we have a screening. Actually, we have a screening checklist that is specific to Burma. It's not yet up on Clinic's website, but the organizers will send it out to everybody who registered after the webinar. So you can use that if it's helpful. And then we have listed some of our other resources here. And also, if you're interested in joining Clinic's network of nonprofit legal service providers, we have a link to read more about that as well. Okay, so that is it for my part, and I will pass it back to you, Gisela.
Thank you so much, Jen and Elisa. On to the next slide. Last, we have Raluca from Catholic Charities Community Services, Archdiocese of New York. Next slide. Raluca has been the Program Director of the Immigration Legal Services Department of Catholic Charities Community Services, Archdiocese of New York since 2005, after having served as a staff attorney in that department for almost 5 years. Prior to joining CCCS, she was a National Association for Public Interest Law Fellow with the Refugee Assistance Project of the Association of the Bar of the City of New York. Thank you for joining us, Raluca. I turn it over to you.
Thank you very much, everyone. Nice to be with you. I would like to specify that my remarks are addressed to those who are on this webinar because for TPS applicants. So it's not so much, I know based on the questions I've seen pop up, there seem to be many on the webinar who are interested in getting answers to questions on their own cases. And so this segment is less geared towards them and more towards program managers who are preparing to assist with TPS. Next slide, please. So one of the things that at least the Catholic Charities in the Archdiocese of New York, we do whenever there's a new program, whether it's TPS or DACA or whatever the program is, the first thing we do is go back to our existing clients to see if any of them are eligible. And so depending on the database you have, it can be a simple search to just search by country of origin or nationality and come up with a list, and then go one by one through the list to find out if your clients already have status, this is not something relevant to them, or if it's something to be considered. So that would be the first step, and those would be our priorities. And if we identify cases, active cases, where it seems like one of our existing clients may be eligible for TPS, then it's up to the attorney on that case or the accredited representative on the case to make a determination with their supervisor as to whether it makes sense, if there are any pitfalls in pursuing TPS. But of course, the ultimate decision is taken with the client, and there has to be a meeting and a discussion of whether it makes sense or not to apply for TPS at this point. Next slide, please. So that was existing clients. In terms of being proactive about approaching possible new clients, again, it's a matter, for us at least, it's a matter of first going through our rosters of consultations to see if anyone approached us in the past. Perhaps we weren't able to take the case, and then proactively reaching out to them to just let them know that TPS is available, not just for themselves, but also for other friends, family members who may be eligible and interested. The next step for us is to update the local referral systems and let them know if we're planning to assist with TPS. This is important in New York because we have large populations of almost every nationality. And so there's always a high demand for services. And so the legal service providers try to get together and figure out who's going to be doing it, who can help, who may not have capacity. In particular, in New York, we have several hotlines whose mission is to link those who are looking for immigration legal services to legal service providers who can help them. Two of them that actually Catholic Charities manages are a New York statewide New Americans hotline and a New York City-wide Action NYC hotline. So we update both of these two hotlines if we have the capacity to take on TPS applications, or if we have special events, for example, a clinic, so that they can be referred to that resource. The next step is to revise staff training and programs and materials for the particular TPS group that we're anticipating serving. So in this instance, we are going to go back to all of our materials for TPS from Venezuela and update them with an eye towards working with the Burmese population, and then we anticipate doing the same for the Haitian population. In fact, we have pretty much updated materials for Nationals of Burma. The next step would be, if we do anticipate an event coming up, we would make up flyers for our communities, and we would get them translated in appropriate languages and disseminate them. Finally, there's outreach into the community. And that's approaching groups that we know work with the Burmese population in this case. We do have one of our staff attorney is actually from Myanmar. And so she's doing a little bit of her own outreach. And we've already gotten some requests for assistance based on that. Next slide, please. So what do we envision, or how do we envision approaching TPS for Burma? At this point, as you can probably tell by my background, we're still working mostly remotely. We are going to the office on a periodic basis, but most of the services, especially with clients, are remote. So the first step for us would be to do light triage over the phone with those who reach out to us for assistance. And by light triage, I mean like literally going through the very basic eligibility requirements and seeing if at least those are met. If somebody seems to be eligible for TPS, the next step is to actually schedule them for an in-depth screening with one of our attorneys or one of our accredited representatives or one of our paralegals. And that becomes a lengthier process where we try to go through all the bars of inadmissibility. The bars to asylum, the inadmissibility grounds, try to see if there are criminal convictions that may be an issue, whether statelessness is an issue, whether the applicant may be in status and what the risks of applying for TPS are or the benefits. And so that is a lengthier process. And again, this is done mostly remotely, but it can be done by WhatsApp or Zoom or by phone. And we use a screening, like an in-depth screening tool to actually go through all of the different requirements and possible pitfalls. And then if the case is particularly complicated or there's a lengthy immigration history, we may need additional documentation from the client before we can decide whether or not to go forward. One of the things that's very important, especially for those who have pending asylum applications, is to definitely get a copy of those applications and review them for possible red flags or things that may be an issue for TPS, including from resettlement or any activity that could be considered, for example, to be to possibly bring up terrorism grounds of giving assistance to a group that may be considered a terrorist group by the U.S. government. So those are just additional considerations. For this reason, because there are so many different layers depending on the immigration history and the possible eligibility for other relief for each TPS applicant. This for us has, it leads us to think that consultations are better in a one-on-one setting and not necessarily in a clinic. Just to explain the terms, a clinic is, or used to be back when everything was done in person, it used to be a one-day event where people came in at the beginning of the day, were assessed for eligibility. If they were eligible, proceeded through to have their applications complete, and then by a next one-day process. Both for Venezuela and TPS and for TPS for Burma, there is a lot of overlap with possible asylum claims. We've determined that it's a better process to actually not do this through a clinic, but to do it through one-on-one consultations, because a lot of follow-up is sometimes necessary. That being said, I would talk about the fact that we are using a clinic process, the clinic process, but in a slightly different way than before. So the next step after a consultation is whether or not we're taking the case. Sorry, can you go back to the last slide? Okay, so couple of considerations on whether we'll take the case and how we take it. Are we limiting our representation to TPS? Let's say the person is eligible for asylum and wants to apply for asylum, or the person has applied for asylum pro se and doesn't have representation. Are we taking on the asylum case, or are we just doing the temporary protected status application? Each service provider is going to make a different determination based on capacity. TPS is much more straightforward than an asylum claim and involves way fewer hours and fewer resources, so it depends on capacity. The point though is that if the determination is made that only the representation will be limited to TPS, then that has to be made very clear to the applicant. The next question, as I was explained before, is this a complex or a straightforward TPS application? If it's straightforward, it can be handled by a paralegal supervised by an attorney or by an accredited representative. If it's complex and we want to take on the case, then it will have to go through to one of the attorneys to be handled directly by them. And then the question comes up as to whether you can do that in-house, you have the capacity, Or if you have a pro bono program, as Catholic Charities does in New York, then if this is something that can be handled by a pro bono attorney with proper training and mentoring. The next possibility is a self-help workshop, and I discussed this briefly before. It is possible, especially when dealing with straightforward applications, that they could be handled in a self-help workshop where people are walked through all of the eligibility requirements, and if they're eligible, they can, attorneys can answer questions without giving legal advice, and people can fill out their own TPS applications and proceed on filing it on their own without representation. So that is a model that enables practitioners and nonprofits to handle a lot more applications than it would be possible in one-on-one direct representation. The last thing is the mixed in-person and remote model, and this is something that we are trying for Venezuelan TPS. And what it basically is, it's all the work, the consultations, the follow-up, the application completion, document gathering, all of that takes place remotely. And then the last step of the process, which is assembling the application, reviewing everything with the applicant, getting the photographs and the money orders, that is the last step, and that one is done in person at a mass event. And that cuts down on the time that has to be spent together in a mass gathering, although in our case, we're going to be doing it outside. And it's good because it actually bridges that gap between dealing with someone in a virtual world and actually coming face to face with your client at the end of the day and putting everything together. So that's something else that people may consider. Next slide, please. Okay, so it is good if you have one to update your screening tool for TPS in particular. We went through that exercise, and I think what we came up with is a much lengthier document than we wanted to. But there are also existing tools out there, so you can use something that someone else created and then customize it to yourself. It's good to have a document checklist to give out to the clients so that they know what they need to bring you. Again, if applicable, any asylum applications or any other kind of applications for immigration benefits must be reviewed, as well as the certificates of disposition. If there are any convictions or arrests, that is a must. So remember to do that. And if taking the case, again, consider, are you just taking the TPS case? Even if you're just taking the TPS, you want to have a conversation with your client about what will be the next step. Let's say if it's denied, will you be pursuing an appeal? Will you be pursuing other forms of relief? So all of that has to go into sort of informing the client and putting it in writing as to what services you're providing. If you're not taking the case, I think TPS in particular, and everyone I think should use non-engagement letters, but even if you don't use a non-engagement letter, I think TPS is a situation where you should, because there are deadlines coming up, and you don't want someone to say, oh, I thought they were helping me and I was just waiting to hear from them, and then they missed the deadline. So you want to have a non-engagement letter that spells out the deadlines. This is the TPS deadline, you must apply by this time. And if you're also considering applying for asylum, you also have 1 year from when you last entered to apply for asylum. So you want to spell that out. Next slide, please. Another thing to do, again, because there are deadlines involved, is set reminders so you don't miss the registration deadline. If you use a system like LawLogix, that's easy to do. And you can set as many reminders as you want, depending on how nervous you're about the deadline. Another reminder to set is not just for yourself and the deadline, but also if you ask the client to come back with certain documents, a copy of their asylum application, for example, or the certificates of disposition, or anything else, you want to set deadlines for them as well, so that it gives you enough time to make an assessment of how to proceed way in advance of the deadline. Another reminder is, no matter what the checklist or the screening tool that you have, it's always good it's always good to review the form itself and the instructions. Sometimes, I know from our practice, sometimes people don't do that. They think the instructions are for people who are doing the applications on their own. Actually, reviewing the instruction is very enlightening and helpful. Last, I think I already touched on that. Review all prior applications for consistency, but also any red flags that you need to address. And again, membership in totalitarian party, violent groups, persecutions of others, firm resettlement issues, arrest and criminal charges abroad. And again, this was mentioned before. If there were arrests abroad, then USCIS is going to expect to see some sort of certificate of disposition for those arrests. And that's in particular for people who are applying for asylum, and part of their asylum claim is that they have been arrested repeatedly. That's something to consider, and probably not very easy to get documentation about politically motivated arrests, but something to consider and at least be prepared to address. Next slide, please. These are some resources that are not ours at Catholic Charities, but these are clinic resources that we found to be very helpful, so we recommend them. And that's it on my part. Thank you.
Thank you so much, Raluca, and to all of the speakers. Additionally, we do see that there are many asking specifically for their own case, for those who are not legal practitioners, but are instead asking questions on your own behalf. We certainly encourage you to seek legal representation as soon as possible. In response to that question, we did want to conduct a very quick poll. Please plug in your answers in the chat room. Our first question is just to check. We understand that today's webinar is very much focused on legal practitioners. We wanted to get a sense if participants are interested in a Zoom call that is focused more towards community members. Please just give us a quick yes or no. We'll give folks just a few seconds to respond to that poll. Thank you so much. And then our second poll question, we wanted to get a sense whether folks are interested in having resources that are translated or have other linguistic needs. We encourage people throughout the question section Q&A to just please add any linguistic needs or challenges that your organization is facing. And that is feedback that all of our organizations can use to better support our communities. Lastly, we have received a lot of questions and we'll address as many as possible. Our speakers have kindly responded to questions directly in the Q&A section. We apologize to those whose questions we do not have time to get to. We will circulate the slides, recording, and resources from our speakers, which may answer many of the questions that you all already have. To kind of, save a bit of time, I think what we'll do today for our Q&A section is I'm going to give 3 questions that seem to be one of the broader questions that have been asked and is more common. And I'll let all of the speakers speak up to see if there's any ones that they would specifically like to answer. So in terms of one of the more common questions, we do see in the Q&A that there continues to be confusion about TPS applicants who apply for asylum. If speakers can clarify this confusion, if there's any difference or impact with applying before or after TPS for those who are lawfully admitted to the United States. Second, we understand that many are concerned about the latest Supreme Court ruling in relation to TPS, and we'd ask the speakers to kind of share their thoughts in how the Supreme Court decision would impact TPS for Burma. And lastly, as discussed partly by our speakers earlier, but there is inquiry about the specific minority groups such as Karen and Chin and whether they qualify as Burmese nationals. If speakers, feel free to plug in for any question that you'd like to address. Thank you so much.
So I can start by answering the asylum question, but since I'm the person that spoke about that, it's obviously I caused some confusion. So my co-panelists, feel free to jump in and say it a different way if that would help. This is confusing, and it's confusing to say it in a way that is clear, but you can absolutely apply for asylum and apply for TPS. You can be a pending asylum application and apply for TPS. It's fine. You can apply for TPS now and then file for asylum after you get TPS, as long as you have not missed the 1-year filing deadline or something like that for asylum. So there's no inherent conflict. You don't have to choose one or the other. The only thing that I was trying to flag is that if you have applied for asylum with the asylum office at USCIS and you go to your interview, and after your interview, the asylum officer is ready to make a decision. If you have TPS and they want to approve your case because you qualify for asylum, you meet the requirements, you were persecuted on the basis of your religion, that's okay. They can give you asylum even if you have TPS. They can approve your case. The only limitation is if they are not going to approve you for asylum, normally they would refer you to immigration court. You would be NTA'd, you would go to immigration court. At that point, you would raise your asylum claim with the immigration judge. However, if at that point when they are going to not approve your case because they think you don't qualify, they cannot refer you to immigration court. They can only, under the reg, deny your application. And that is where it ends for now. So I don't know if that helps. I don't know if anybody else wants to jump in and clarify anything that I'm missing.
I would just add, because I think we are seeing that question a lot from community members who are not practitioners. So I think what Jen is talking about is pretty complex and gets into a lot of technical aspects of how the procedure works. And so if that's a big question for you, apart from knowing that you can pursue both at the same time, I think it is really important to consult with an expert about your specific case so you can determine what's the best strategy for you, because it's not necessarily going to be one answer for everybody. And as Jen mentioned, there are a lot of other things to consider, such as bars to applying for asylum if you delay in filing. So it is a very complex issue. And we would suggest for people who are not practitioners and who are concerned about their own cases or cases of people in the community, their family members, we really encourage people to speak with an immigration law expert so you can get advice about your particular case.
I just wanted to add something quickly to that, which is that if you are applying for asylum and the asylum application is denied, you can apply for TPS even if after the deadline with late initial registration. Now, you may be in proceedings at that point, which will complicate things a little bit, but hopefully new ways of handling cases of people who have temporary relief will make that process easier.
There was another question that I think that was mentioned about the recent Supreme Court decision and what that means for Burma TPS. That Supreme Court decision, Sanchez v. Mayorkas, deals specifically with another, I guess almost procedural issue in terms of people who have TPS but have another path to permanent residency, whether they can pursue what's called adjustment of status here in the United States and apply for a green card here, or whether they would have to depart the United States and apply for permanent residency abroad. So this does not affect broadly TPS for Burma. It affects certain people who have TPS and are trying to pursue a green card based on some other avenue, like, for example, a family-based petition or an employment-based petition. And as I think Jen mentioned earlier in the presentation, TPS by itself is not going to lead to permanent residency. So this is sort of a separate issue that might come into play for some TPS recipients or applicants who have maybe a family member who's able to file a petition for them, but it doesn't have a direct impact on whether or not people from Burma are going to be able to apply for TPS. Hope that answers that question. And was there a third question that you mentioned?
Yes, I think one question just regarding some of the specific minority groups, Karen Chin, how would folks have more information about how they should be handling the TPS application process?
Well, I'll start us off since I talked about it, but other presenters might have more information. I'm not an expert in Burmese citizenship law. My understanding is that it is very complex and that there are different tiers of citizenship. There's, a focus that's based on ethnicity. So there are certain minority groups that are excluded from citizenship. And then there are others who, according to Burmese law, should be considered citizens, but may have a lot of difficulty in obtaining national identity documents that prove that. So what we were discussing is that if you are not technically a national of Burma, for example, Rohingya, who are not considered citizens of Burma, you may be able to still qualify for TPS based on being stateless and also showing that you last habitually resided in Burma. And then if you are someone who is a citizen or a national of Burma, but you don't have an identity document, you may still be able to apply by using other types of secondary evidence to try and show that you are a national. And I'll just let others weigh in if they have they can provide more details about how that might work.
And I know that we have, we're short on time, and I want to make sure I'm respectful of everyone's schedule. We know there's been a lot of questions that we haven't been able to address, but thank you so much to the speakers. They've been able to answer over about 20 questions in the back as the webinar training has been going on. Know that we will continue to provide resources and we would appreciate any feedback. If folks are interested in more resources or have a specific need in their community, please let us know. We will share that with the speakers so that we can see what we need to provide. Oh, I'm sorry, was there a... But yeah, I will let the speakers, if there's any last thoughts that you all have for any of the participants.
Thanks for inviting us, Bella.
Thank you, Jen. And thank you everyone for joining us. Feel free to reach out to all of us. We will follow up with information as well as all the contact information of the speakers today. Thank you, everyone. Have a great day.
Thank you, everybody.
Thank you.